Good afternoon, everybody. Welcome to the second OAKland webinar. As you may remember, the first one considered different working practices under the working at home as a result of COVID. Now we're going to get back to rather more straightforward data privacy matters. Before we go on to that, I'd just like to briefly introduce you to lecocqassociate. As you may well know, lecocqassociate is a law firm based in Geneva with offices in Malta, Dubai, and Abu Dhabi. And OAKland Group is a group based also in Geneva, but with a subsidiary office in Paris. We have a slightly different team this time compared to last time, and we'd like to welcome Krista Vimont, who is a partner at lecocqassociate here in Geneva. Krista is an Australian lawyer who works predominantly on cross-border transactions, and she's a member of the Geneva Bar. We also welcome Joris Fazel, who is a Swiss avocat and expert in the data privacy regime. And last but by no means least, we welcome Laurent Marcoz from OAKland, who is the head of their GDPR practice. Right, Joris. Before we go on, can we just have a quick brief recap, please, on the nature of data privacy and what data is subject to this legislation, please?
Yes, thank you, James. So, of course, we wanted to start with a little introduction with the basics. So, what is data protection and what is a data? A data, so it is a data relating to an individual who is identified or identifiable. It's not, as a lot of people may think, just name and contact details. It's not also dependent on being confidential, and it's not only information about people's personal lives. So we can have example of data like bank account numbers, IP addresses, but also some emails you can exchange with colleagues or employers or your clients. So it is important to keep in mind that data protection is a key part of the right to privacy, and it's centered mostly on 3 points: imposing rules on the way organizations use people's personal data, but also giving individual rights over the data. So what is my employer doing with my data, or what should I do with my client's data? And third point, really important, is establishing regulation to enforce the law.
Okay, that's great. Thanks, Joris. So now we've had a brief definition or overview of what data is. Can you give an overview of the type of circumstances or legal transactions when we have to consider these data privacy matters, please? Is it a broad definition or is it a very narrow legalistic definition, please?
So I would say it's a broad definition, since any kind of legal transaction involving data about individuals is likely to be impacted by the regulation. So first of all, data protection impacts all businesses, because now businesses are using more data than ever. So of course it increased the risk of a data breach. And who said data breach said negative publicity, risk of client loss, but also damage for the brand or the company name. Now we give you here some legal transaction impacted by data protection regulation. First, we've got contracting with a service provider who will process individuals' data. For companies doing, for example, a merger and acquisition, it would be the whole due diligence process on the target company. And also a litigation procedure. So every people, lawyers, clients involved in a litigation procedure will be impacted by the data protection regulation. Well, last example here is for multinational. They must be aware that they have to consider not only the place they are for the data, but also consider data protection regulation obligations in every country they are in. So now that we've seen those examples, I would like to take you on the road to GDPR. This is exactly this nice road, and this road started in '95 when the EU published the first directive called the Data Protection Directive. Back in '95, this directive was quickly criticized for being inconsistent and out of date. First of all, inconsistent because it was implemented differently in every member state, and out of date because back in '95, this directive took into account all the technology that came at that time, and of course also the individuals and what is really data protection. So the EU had to rethink, and we work on a new project, so now called the GDPR, who came in May 2018 into forces. And this GDPR and this year of 2018 was really the year where data protection went mainstream. So we can see here also on our little road that in September 2017, the Swiss authorities, the Federal Council, presented a draft or a totally revised Data Protection Act in order to be in equivalence with the GDPR. So since I would say 2-3 years now, data protection is really a topic for every companies and in public agenda as well. It's really important to know what is data protection. And here in Switzerland, we need also to take into account the regulation in Europe in order to have the revised Data Protection Act or revised Data Protection Act compliant with the GDPR.
Okay, that's great. So you mentioned just there an issue of equivalency. I assume from this roadmap here that effectively the Swiss legislation is beginning to follow the GDPR, at least in its substance, even if it's not in its detail. And so is that, why is that in your opinion? And do we have an idea that the EU Commission is, whether the EU Commission is actually going to consider that this new draft legislation is going to be adequate or not, so as to allow cross-border use of data?
Mm-hmm. That's actually a really actual question, because strictly speaking, as you surely know, Switzerland is only obliged to take over the data protection regulations regarding the Schengen Agreement. But since we are in the middle of Europe, of course, we have to consider EU regulation. And in order for Switzerland to be recognized as a third country with comparable data protection to EU, we've got to take into account the GDPR and have this adequacy and adequate decision from the EU Commission. And James, we've got actually a breaking news from last week. We learned that the EU Commission postponed its adequacy decision on Switzerland. So it was not because of Switzerland or the draft, but it was because the EU Commission is waiting for a verdict from the Court of Justice of Europe. And this Court of Justice must clarify whether the EU standard contractual clauses, known as the SCCs, and the Privacy Shield, this is this agreement between the US and the EU, are sufficient as a basis for the transfer of personal data between EU citizens to the US. So the EU Commission is waiting for this decision. That's why they postpone the adequacy decision on Switzerland. But I would say that for Switzerland, it must also be a wake-up call to our legislator in order to move forward with the draft and have it as soon as possible entry into force in order to get this adequacy decision. Since, as you can guess, and as we know, it is really important for Swiss companies and businesses to have this adequacy decision in order to transfer data of the client, of the employers, and the employees, sorry, in Europe, from Switzerland to Europe and vice versa.
Okay, that's great. Thank you very much, Joris.
And now, since we talked about the draft, I would like to just have a quick look on the differences between the current Data Protection Act in Switzerland and the draft. Exactly. So we have 6 key points we'll just go through with you now. So the first one is the protection object. So the current law regulated the protection of data of both natural and legal persons, and the draft is only now focused on the individuals. This is one of the big changes. And no worries, companies are still protected by other regulations like unfair competition rules or privacy personality rights. The second point are the sanctions. You have to know that the current law, does not state clear sanctions, but the draft go further, and an individual who will be breaching the law intentionally could be fined up to 250,000 Swiss francs. So this is also a new thing. Let's move to the third point, particularly sensitive personal data. So those data like ethnic origins, political opinions, religious belief. The draft is extending the list of those data falling into this category of sensitive personal data, which is also in order to be compliant with the GDPR and take what GDPR also extend in Switzerland. The fourth point is the data protection through technology design and data protection by privacy default. This is more a point important for the data processors and controllers who will need to increase due diligence requirement. Due diligence requirement, of course, in order to reduce the risk of a breach. As we saw before, the breach can lead to a lot of damages for the companies, for example. The fifth point is the privacy impact assessment. So there is an increase the risk to the privacy of fundamental rights of the individual. Data controllers and data processors must carry out a data protection impact assessment. This is also something that is coming from the GDPR. And our last point for those differences on the key points is the notification of data protection breaches. The data controller must notify the Federal Data Protection and Information Commissioners, called the FDPIC in Switzerland, of a data breach as soon as possible. That's what the draft is saying in terms of deadline. So as soon as possible, if there is a high risk to the privacy or fundamental rights of the data subject. Also, last point, sorry, if necessary, the data subject must also be informed. So those are, James, the 6 key points we choose to show the differences between the current and the draft.
Okay, that's great. Thank you very much, Joris. I think looking at those, one can see a certain parallel with what's going on in the GDPR, although the sanctions are considerably less than in GDPR. There are sanctions, and of course, privacy by design is the hallmark of the GDPR. So that's great. So we've now looked at the difference between the current existing legislation within Switzerland and the draft Data Protection Act. Krista, can you please talk us through the differences between the proposed act and the existing GDPR, please?
Yeah, glad. There's, I mean, just as a general comment, the differences between the draft Data Protection Act and the GDPR aren't significant, but there are a couple of specificities. So I'm going to go through the main sort of differences today. The first is in respect of the geographical scope of the GDPR as opposed to the draft Data Protection Act. As most people listening today would probably know, the reason why we're talking about the GDPR in Switzerland is because the GDPR has a principle of extraterritoriality, which means that a business here in Switzerland, if it's targeting an individual who's based in the EU, or if it's providing goods or services to someone in the EU, will have to comply with the GDPR in respect of the processing of those EU residents' personal data. The draft Data Protection Act, and in fact the current Data Protection Act in Switzerland, doesn't explicitly state whether it applies outside of Switzerland. It's clear, obviously, that the Swiss law applies to processing activities that are taking place here by Swiss companies. There was a principal decision about Google Street View that was rendered, and in that decision it was decided that if the collection of personal data occurs in Switzerland, then the Data Protection Act will apply. But as to extraterritoriality, so perhaps a client based in Switzerland and the processing is taking place by an entity outside of Switzerland, there's nothing explicit in the Swiss law and the draft Swiss law that talks about that. The second point is in respect of fines. So as Doris raised before, the fines in the draft Data Protection Act have certainly increased. A company for an intentional breach could risk a fine of up to 250,000 francs. As some of you might know, the GDPR goes a lot further than that, and for an intentional breach, a fine might be up to 20 million euros or 4% of global sales, whichever is the highest. So it's a significant difference in terms of the amount of fines. The third difference that I wanted to raise is in respect of data breaches. Again, as Doris said, in the draft Data Protection Act, a data breach must be notified to the Commissioner in Switzerland within a reasonable time. Whereas under the GDPR, the notification must be made within 72 hours. So it remains to be seen whether 72 hours might be considered sort of the rule of thumb in Switzerland as being a reasonable period of time. But I would say that it really depends, because the Swiss law leaves that latitude. It really depends on the situation as to whether it should be done within 48, 72 hours or a week. Data portability is a right that is for the data subjects and exists under the GDPR. It allows a data subject to request a controller to provide the data that the personal data it holds on them in a structured and machine-readable way, so that data might be able to be moved from one controller to another. So, say a telephone provider from one to the new telephone provider. It's a right that doesn't exist under the DPA, and the only way that it can really exist under the GDPR is if the relationship between the controller and the data subject was undertaken pursuant to consent or contract, and if the data processing is taking place by automated means. And the final difference that I wanted to raise between the draft DPA and the GDPR is in respect of how the legislators approach sensitive personal data. Now, in the draft Data Protection Act, the processing of sensitive personal data can be undertaken under a set of circumstances, whereas under the GDPR, the way that it's drafted is that the processing of sensitive personal data is not allowed unless there are certain safeguards that are put in place. So it's just a difference in approach.
So it looks as though the GDPR is still relatively more prescriptive compared to the draft Swiss legislation. Is that correct?
Exactly, and it's, I mean, everybody's saying in Europe and in Switzerland as well that the GDPR is sort of the gold standard of data protection in Europe.
Okay, that's great. So, Krista, you've actually kindly set us out a few examples of how the various legislations and jurisdictions apply to certain circumstances. So, could you please talk about that, please?
Definitely. So, what we've done today is we're presenting to you two different examples, two banks that we've created. The first bank is Swiss, and the second bank is in France. So here we'll go through the example of Banque Escalade, which is based in Geneva, its obligations under the various data protection regimes. Just as an initial standpoint, as most of the people listening might know, if we're looking at a bank, obviously the bank in Switzerland needs to be in compliance with all of the FINMA circulars as well, and there's quite a lot of rules in respect of how client identifying data is treated and processed. Today I'm going to go through the data protection regimes, so not so much the client identifying data regime. So we have our Swiss bank, and our Swiss bank is looking at how it should be processing data of three of its clients. Its first client, Marie, is French, and she lives in France. So the Swiss bank is based in Switzerland and is processing data in Switzerland, which means that initially the data protection in Switzerland applies to this relationship, and the bank must respect the DPA. As I mentioned earlier, and the reason why we're all talking about the GDPR is this extraterritoriality. The processing of the data of a French person or someone based in France means that the GDPR also applies here. And then the third layer to look at is whether the local French law in respect of data protection applies. Now, the French law of 1978 in respect of data protection was amended to incorporate the GDPR. As some of you would know, because the GDPR is a regulation, it's automatically applied across all of the states as opposed to its predecessor, which was a directive. But most member states have actually implemented the GDPR into their local law or amended the local law. And in respect of the French law, where there's no specific rule or regulation in the GDPR, and the processing is taking place outside of France, the French law will apply. So the Swiss bank might need to look at what particular rules under the French law would apply to this relationship. If we go to Grégoire, very simple. Grégoire is based in Geneva. The bank is Swiss and based in Geneva, so the Data Protection Act applies, and there's no initial sign that the GDPR would apply. Then we move on to Kate, who's a little bit more complex because, as you all know, the UK is leaving the EU. The EU laws continue to apply in the UK until the 31st of December of 2020. So the GDPR will apply because Kate, for now, is in the UK. The Swiss law will apply because the bank is processing in Switzerland and is based in Switzerland. And under the Data Protection Act in the UK, which has also implemented the GDPR, like in France, the law states that where processing takes place of a person in the UK by a processor based outside the EU, the UK Data Protection Act applies. So here we're looking at the GDPR, the Swiss Data Protection Act, and the UK Data Protection Act, which apply to Kate. Okay,
so we'll have to wait till Brexit occurs and to see what happens to that, because it may get even more complicated depending on whether the European Commission views the UK privacy regime to be adequate or not.
Exactly, and we're going to give a presentation on that particular topic towards the end of the year. Hopefully, we'll have a little bit more information between now and then.
Okay, great, thank you. So now you've got an example of Banque Eiffel, which is, I assume, a French bank. Could you actually give a quick outline as to the legal regime there and what the bank should be thinking about in terms of data rights?
Definitely. So Banque Eiffel is our French bank, and our three clients of Banque Escalade also have an account with Banque Eiffel. And so we look at the three different relationships. So Marie is French, based in France, very straightforward. The GDPR applies, and the French law applies because the processing is taking place in France by a French establishment. In respect of Grégoire, it's a little bit more perhaps complex. Obviously, the GDPR applies. As I said, with respect to Marie, the processing is taking place in France by a French establishment, so the French law will apply to this relationship as well. And in respect of the Data Protection Act in Switzerland, because we're looking at Grégoire, who is a Swiss resident, as I said earlier, there's nothing in the law in Switzerland that expressly states whether the law has extraterritoriality. It might be worth one day testing. What I can say, however, is that, as I mentioned before, the GDPR is really the gold standard. And so Grégoire will be satisfied by using the GDPR in respect of the relationship and certainly also in respect of the French law. And then finally, we look at Kate. Again, the French law applies because the bank is established in France. The GDPR applies as well. And at the moment, the UK law actually doesn't apply to this relationship because the bank is established in France, so in the EU, which means that the UK Data Protection Act is outside the scope here.
Okay, that's great. So the case of Gregoire is perhaps the most interesting here, whether he could seek to rely on both the GDPR and the new act within Switzerland. Do we have a view as to whether he'd be able to or not, based on the lack of extraterritoriality within the proposed act in Switzerland?
It's a good question. It really depends on the avenue that Gregoire will want to take, and what the particular situation is as to whether he would want to try and go down that road. I mean, it's obvious that the GDPR applies, so he's going to be satisfied with that, and it remains to be seen.
Okay, Krista, that's great. Thank you very much. So, Laurent, you are the head of the GDPR practice at OAKland, and so you're more involved in the practical implementation of GDPR issues across Europe. I know you've been working on a number of cases, so let's imagine a case in which there's a Geneva or Swiss-based online retailer, which is a B2C retailer, offering its goods across the EU and, of course, in Switzerland. How would you approach this, please, in terms of practice?
Okay, James, it's a frequent misunderstanding that a Swiss company, because the LPV is adequate, as Joris said, that the company is free to process EU citizens' personal data without any constraints. This is the #1 error we see with many Swiss companies.
So in practical terms, what does that mean in terms of how they should plan and adhere to the various regulations?
Matter of fact, the adequacy principle only covers the transborder situation where personal data are moved out of the EU territory between accredited actors. In any other situation where a data control processor is not established in the European country and processes data concerning individuals located within the EU, then the GDPR imposes an obligation to appoint a representative in the European Union, unless, of course, they meet the exemption criteria as per Article 27.
Okay, so here we have a practical example of a Swiss company needing to apply the two jurisdictions as Krista discussed. Is that correct?
Yes, exactly. This is the same for either a data controller or a data processor, so it's very broad. Our practical advice is, if in doubt, appoint a representative, especially if you are a large or a growing company. The reputational and financial damage for not doing so is definitely too important.
Okay, so what does this representative under the GDPR do from a practical standpoint, please?
The representative in the union may be a natural or a legal person established in the union and able to represent a data controller or processor established outside the union with regard to their respective obligation under the GDPR.
So the representative can either be a company or an individual, is that right?
Yeah, exactly. It can be both. And,
all right.
In practice, the function of a representative in the union can be exercised based on the service contract concluded with an individual or an organization, and can therefore be assumed by the wide range of commercial and non-commercial entities, such as law firms, consultancies, private companies, and so on. But the key point here is that the entity is established in the EU. And by the way, one representative can also act on behalf of several non-EU controllers or processors.
Okay, so in your experience, what should you be looking for in practical terms from an Article 27 representative, and how should you go about appointing one?
The GDPR states that the representative should be explicitly designated by a written mandate of the controller or the processor to act on its behalf and with regard to its obligation under this regulation.
All right, so bearing in mind that the data processor takes on a series of legal risks, does the representative also take on those risks as well, or in managing this data or not?
No, absolutely not. The principle is that the controller or processor retains all the risk for data processing. There is no legal substitution affecting the responsibility or liability of the controller or processor under the GDPR. It's always the company engaging the representative that remains legally responsible for correctly managing data.
All right then, so if effectively, am I right in saying that the representative is a contact point or a letterbox with no strong duties in this relationship?
No, it's more than this actually. There's more to it. The representative needs to maintain a record of processing activities being undertaken by the controller or processor. So the representative is reliant upon the data controller or data processor informing it of both the type of processing taking place on an ongoing basis. The reason for this is twofold. Firstly, the representative needs to be able to tell the supervisory authority, such as the CNIL in France, what our data is being processed in the event of a request or audit. In practice, this means that the supervisory authority would contact the representative in connection with any matter relating to the compliance obligations of the controller or processor who is established outside the union. And the representative must be able to facilitate an informational or procedural exchange between a requesting supervisory authority and a controller or processor established outside the union. It is the representative's own legal responsibility to be able to provide processing information when being addressed by a supervisory authority.
Okay. So what you're saying, if I understand right, Laurent, is that whilst he doesn't have any legal liability, for what is being done with the data, it is his or her duty to know what is being done with that information. Yes. Okay, you said that there were two reasons for it not being a simple contact or letterbox. What's the second one, please?
Yes, you're right. Secondly, EU citizens whose data is being processed have data subjects' rights and can or are allowed to inquire into the type of processing data taking place. They need someone to approach to exercise these rights.
Okay, so the representative is facing both the individual data subject and also the processor of data, and needs to be at all times responsible towards the regulatory supervisory body at all times. Is that right?
Yes, absolutely.
Oh, okay. So, right, now we know what a representative does under Article 27. What should I look for in establishing or identifying the correct representative for my specific company?
Most important is communication. While not in itself responsible for complying with data subjects' rights, the representative must facilitate the communication between data subjects and the data controller or processor. Without this communication, life becomes very difficult.
Okay, so specifically, communication with who and how, please?
The representative in the EU must therefore be in a position to efficiently communicate with data subjects and cooperate with the supervisory authorities concerned. This means that this communication should in principle take place in the language used by the supervisory authorities and the data subject concerned. The whole idea is that the language of the data subject is respected to the maximum extent possible. Ultimately, the availability of a representative is essential in order to ensure that the data subjects and supervisory authorities will be able to establish contact easily with the non-EU controller or processor.
Right, so effectively we're looking for a multilingual office, ideally, as I understand it. All right, that's great. Now, we've talked about our notional Geneva-based B2C retailer. Now, imagine that our retailer now, which traditionally up until now has only been selling in France, decides to sell in Spain what does it have to do to be compliant? I've heard of the one-shop system by which organizations involving trans-border processing can designate one lead supervisory authority. Is this system the same for somebody who is processing data from outside the EU under the Article 27?
No, it's actually compatible. The one-stop shop system can only be used by controllers or processors having their main establishment located within the EU. For controllers or processors having no establishment within the EU, such as the case with our Geneva-based B2C company, the Article 27 representative will have to be able to deal with each and every single national supervisory authority where data subject is issue requests.
Okay, so the reality is that a small company like this, things going to get quite complicated managerial and linguistically quite quickly.
Yeah, you may say so. Being an Article 27 representative is not just a pass-through. And as a controller or processor, prior signing any contract, make sure that your Article 27 representative has the minimum skills required for such a mandate.
Okay, so we've now discussed the case in which there is a Geneva-based company which is selling in France and then all around the rest of Europe, and you're saying that based on Article 27, the ideal Article 27 representative would be somebody capable of speaking all or most of those languages as a minimum. Let's take a situation in which this notional company decides that because of its expansion, this company decides to create a subsidiary within the EU, either as a headco or as a subsidiary, depending on its fiscal decisions. What would be the change in regulation in that situation?
Well, ultimately, there would be no need for an EU representative under Article 27. Of course, provided data is being processed within the EU. So the company would have to adhere to Swiss law for client processed within Switzerland and EU law for those within the EU. It would also likely benefit from the one-stop shop principle at this point.
All right, okay, so that's good. So the mere fact of opening a subsidiary may lead to the use of the one-stop subsidiary, one-stop principle. Okay, so by changing the corporate structure of the company, their legal obligations change a lot. That's effectively what you're saying here. All right. Last but by no means least, in your experience, let's discuss the role of the DPO, the Data Protection Officer within the company. In our situation here, in fact, in all of our situations here, can a single DPO work as both a DPO and an Article 27 representative at the same time?
Unfortunately not. The European Data Protection Board does not consider the function of a representative in the Union as being compatible with the role of DPO be established in the Union. Fundamentally, this is because the drafters of the legislation felt that there would be too many conflicts of interest between the role of representative and that of the DPO.
And in what way specifically would there be conflicts?
It all comes down to autonomy. A controller or processor is required that its DPO does not receive any instructions regarding the exercise of his or her tasks, as they are required to be independent from the management of the business. And this does not appear to be compatible with the role of the representative, which, as the name implies, do not appear to be independent of the company's management.
Okay, so if I understand correctly, a representative can represent numerous companies within the EU, and a DPO can also act as an outsourced DPO for a number of companies too. But most importantly, a company or person cannot act as a DPO and a representative for the very same company.
That's correct, James.
Okay, that's great. Thank you very much, Laurent. This draws to a close this second webinar. We hope that it's been an interesting introduction to the issues of the GDPR and the draft Swiss law on data privacy. If you have any questions, please do not hesitate to contact Nada on the email currently on your screen. Thank you very much and look forward to seeing you again soon.